Okay, everyone, good afternoon. It's just gone past 5 p.m. here in Singapore. Good morning if you are joining us from Europe. My name is Baldev Binder, and I'm the Managing Director of Blackstone and Gold. Thank you for joining our webinar today on the very interesting topic of payments under letters of credit. And in particular, we'll be talking about the recent case of Credit Agricole against PPT Energy. There are many things I want to say about this case, but I'm also quite cognizant that the audience would consist of some lawyers, some bankers, and so there are varying degrees of technicality involved. I've got quite a few slides to get through, and unlike my normal presentations, I think my slides this time will have a lot more words than they would have pictures. So let's get started. The webinar today is going to be focused on letters of credit, and we'll start right from the get-go and jump right in. And these are the policy considerations when it comes to a letter of credit. There are multiple policy considerations, and sometimes when people read the law about letters of credit, there is this sense of not quite understanding the justice of what's being done in the case. And that's because there's this underlying, very strong, entrenched policy considerations that underpin a letter of credit. And I've put that on the left of the screen over here. At the topmost, what is the purpose of a letter of credit? It's effectively meant to serve the function of cash. It's meant to be as good as cash, meaning that the bank doesn't get involved in arguments or quarrels about disputes and the like. The bank's job is not to deal with the goods or whether it's conforming goods or whether there were goods in the first place, but more to do with the documents. That's their role. The BLs that feature quite predominantly in international trade transactions are typically held by a bank as security, and that's typically one of the documents that come into a letter of credit function, apart from oil, and I'll come to that in a second. Banks, the reason why letters of credit are so entrenched and so in favor of payment is that the bank's role is not an arbiter of whether the trade has truly happened or not. The bank can't investigate. It is meant to check on its face whether the documents are conforming to what the requirements are. If they are conforming, then the bank's job is to pay. The risk being taken by the bank is actually on the, strictly speaking, on the applicant, because the applicant is the one that applies for the LC. And so when the bank opens an LC on behalf of its applicant, naturally it will have one eye on the applicant for payment, apart from also whatever security it might have. The only ground, apart from conforming documents, that I saw some of the comments in our flyer presentation, which is quite correct. The only ground, apart from conforming documents or non-conforming documents being presented, to vitiate a presentation made under an LC would be what we call the beneficiary's fraud. So it doesn't matter if anybody else has done some fraud somewhere down the chain, it is the beneficiary's conduct that is being examined. And if the beneficiary's hands are not clean, then I think the law comes into aid of the bank to say that it should not pay in circumstances where the beneficiary's hands are not clean. I ask you to hold on to that thought because this is going to be a repeating theme in the case of Credit Agricole versus PPT. The last policy consideration really is that the documents received by the bank, it's an extension of an earlier point. As long as the documents are compliant on its face, the bank shouldn't actually go and investigate to see whether documents are actually legitimate, whether they have been forged, whether they are fake, whether they've been signed correctly, and so on. Nullities, null documents don't concern us at all. Of this on the left side, I have now introduced on the right side a new consideration that I think people should think about. And this new consideration is this. In the wake of the 2020 trade fraud scandals, should banks be used to facilitate fraud? If there's a very strict dichotomy to ensure that the underlying fraud of the transaction does not taint the presentation and the payment under the LC, then aren't we really not rewarding what I call the conduit trader The content trader is the person that passes documents through without really having skin in the game. And so, are we not encouraging a system where the risk is passed on to the bank? Traders can facilitate strings of trades, not really worry too much about the robustness, the rigor, the authenticity of the trade, and yet push it to the banks, because payment will come through the banks as long as we do a box-ticking exercise, which is known as the LC payment requirements. So before we talk about Credit Agricole this afternoon, I'm going to break my webinar into a few parts. It is technical in nature. I ask you to bear with me. I am going to talk about the case, and I'm going to go through sections of the case law, so bear with me there as well. It is important. I normally don't give webinars about case law, but I think in this case that a bit of dissecting is needed. The case was heard before the Singapore International Court by Justice Jeremy Cook, and this is my commentary over here. Has no disrespect to the Honourable Justice. It is a dissection, an objective dissection of the case. Before I get into the case itself, I've put this slide here just to remind everyone about what circular trades are all about. I've done this slide, I don't know, 5-6 years ago, well before the trade fraud scandals have happened. And I've gone about giving seminar after seminar on this very topic of the nature of circular trades. And I bring this right at the start because the Honourable Judge in this case commented that there's nothing really offensive or objectionable about circular trades. What was wrong over here was that there was a fabricated contract, which we will come to at the end of the chain, and that made the circular trades unlawful. But in and of itself, circular trades are not unlawful. And I stopped there because I think that sort of statement in itself, I completely agree on one hand. But on the other hand, there is an examination that needs to be done as to how a circular trade is done. I've put this diagram on the screen, and this typically involves, we've seen numerous cases of this nature well before the trade fraud scandals, where a seller has a cargo, has a BL, and it's got a long voyage going maybe from South Africa, South America to China, for example. And that's a long voyage. And during this time, the seller thinks, well, I don't need to actually give my BL to anyone just yet. Let me try to monetize it. So I send it on a little round trip, B, C, D, back to A again, and then off I sell it to E. In and of itself, no objection there. I have objections on some nuances, and the nuances are this. Number one, you can't sell the goods more than once. So if A has sold the goods to E already on day one, it can't go about creating this what I call it best synthetic trade between a bunch of parties and moving it around. In terms of the circular trade, point number two, we have seen in all sorts of commodity types, not oil, metals, agri, original BLs go in that chain and move back up to A. And there is a legitimate purpose of using the original BLs. There are repo arrangements where BLs go from party B and then back onto A again. All of these are legitimate trade structures. My only caveat is this. Doing circular trade is completely fine. The point of it is that everyone needs to know it's a circular trade. Everyone needs to know what is going on over here. If everyone knows, and all the big traders do sophisticated structures of this nature, it's an element, there's a big question mark where there's a financing structure, where there's a physical trade. But if all the traders do it in that regard, I don't really have an objection to it. My objection comes when one of the parties doesn't tell the nature of the circular trade. Because when you involve third parties, financing B, financing C, financing D, and they don't know that the nature of the trade, then I think that's where it becomes a bit murky. And that brings us very neatly into the actual case of Credit Agricole. Now, this is one of the few diagrams I have on the screen. I know it's complicated, but let me talk through what the facts of the Credit Agricole case is. It arises from the Zenrock chain of oil contracts in 2020. Zenrock famously now has gone into judicial management, into liquidation, into judicial management, and then into liquidation. But the chain of contracts over here involved in all cargo, I believe, from the Congo to somewhere in China, and that was a long voyage. Total, who were the ones who were at the start of the chain, also happened to be at the end of the chain. And I say this as point number one because the diagram I just showed you from 5-6 years ago had the same thing. Party at the start and party at the end are actually the ones sending the documents to each other or trading with each other. And during this long voyage, there seems to be a circular trade in itself. So Total sent the documents on a bit of a round trip. I don't think it knew that Zenrock was sending a whole new sub-circle of a round trip within that circle. But that's what went on. Zenrock decided to go and create a different sub-circle, sub-round tripping exercise. Goods went from Total on the left to SOCA onto Zenrock in blue, right in the middle of the screen. Now, I've divided the screen into green and blue because these are two separate contracts, and this is where the deception has happened. Zenrock presented to ING a certain trade which is in green. That means SOCA selling to Zenrock, Zenrock selling on to Total. That's the section in green. That's what I've written as the true contract. The pricing at that time was negative, and the pricing is important to remember in this case. The pricing in 2020, if you remember, was Platts with a negative sum to it. On the other hand, unbeknown to ING and to the banks financing the green sector, was Zenrock trying to create a structure in blue over here. And in creating the structure in blue, that's how they roped in PPT. PPT in this case, most charitably I can describe as the conduit trader. The trader being asked to pass through documents to then circulate it back to Zenrock. Credit Agricole was brought in to to open an LC in favor of PPT. What happened subsequently then is that you've got, naturally with all of these things, Zenrock had access to two lines of financing. The key part in blue over here is that it inflated the value of the cargo significantly. And if I got my numbers right, it's something like 87% higher than what the cargo should have been. 87%. And by doing so, Zenrock then got access to funding that was 87% higher than the value of the cargo. And it then sent the documents around, it then created, there was no documents really being sent around. It then created a chain of sale contracts around it so that ostensibly on paper, the goods were meant to move from Zenrock to a company called Shandong, to then PPT, and then back to Zenrock again. Did Credit Agricole know about what's happening on the green side of things? No. Credit Agricole was simply doing opening an LC where it saw the value of the cargo that was being sold from PPT to Zenrock, and then it saw the fabricated contract. And this is where the illegality happens, the fabricated contract on the right, which involves Total buying the goods back from Zenrock at a premium. That's why there's a plus sign in all of it. So the actual state of affairs in green was all involving negative value trading of cargo. The fabricated chain of contracts, the one fabricated chain of contract was involving a premium to that cargo. And and linked to that were other side contracts created by Zenrock selling to Shandong and then on to PPT. In this case, the goods went down this line, Total, SOCA, Zenrock, and then back to Total again. But where it unravels is here. Total then received two notices of assignment, one from ING and one from Credit Agricole, sort of saying that these goods, the contract, the receivable owed to Zenrock has been assigned to the respective bank. And that's where Credit Agricole got wind of what seemed to be a double financing and a fraud. Credit Agricole then waited, and I think that's maybe one of the lessons over here. Credit Agricole waited to get an injunction in place only a month or 6 weeks later, I think, from the time it suspected of this discrepancy between two competing claims. So at one point, Credit Agricole discovered that there is a realistic chance of double financing that has occurred, and then it took out an injunction to pay, not to pay Zenrock before the due date of payment. Now, for people that are not familiar with LCs, typically how it works is you present the documents. At the time the documents are presented, the bank normally, I'm just using one bank, not to confuse people. The bank that receives the documents has 5 days to confirm whether the documents are confirming or not, and then after that, forever hold their peace sort of thing. So then the bank has to pay upon the due date, and the due date, before the payment of the due date, Credit Agricole in this case then applied for an injunction not to pay on the grounds that there has been fraudulent fraud. What happened subsequently then is that to discharge the injunction, Credit Agricole then paid the payment value, which I think was a staggering sum of some $20 plus million, into I think it paid to PPT, and this was guaranteed by Bank of China in the sense that if pending the court's decision, if PPT was held to not be entitled to the money, then Bank of China will guarantee the repayment of that money. That was the arrangement. Come January this year, I believe, the court then decided that PPT was entitled to the payment, and Credit Agricole's allegations of fraud and so on do not taint the claim under the letter of credit. Let's examine what exactly was said in the judgment. There are many issues that were described in the judgment. I've put across some of the major issues I think I wanted to discuss, and these, broadly speaking, I think fall within two categories. One to do with whether PPT had acted fraudulently, and I use the word loosely when I say fraudulently, and the second being whether the letter of indemnity, which is in the case of oil, instead of transferring BLs, a letter of indemnity itself is used as a form of a bridging document whereby there are warranties as to title, warranties as to ability to transfer title and endorse BLs and so on. Let's start from the top as to what the issues were and what the decision arose from there. The headline concern really was that did PPT, remember right at the start of this webinar, the one way to stop payment under an LC is to show that the beneficiary had acted fraudulently. So the question before the court was, did PPT act fraudulently? And the factors put forward to the court was the points I've put in bullet over there. Point number one, the prices were inflated, as I mentioned, 87% higher than what the actual cargo value was. The deal was a pre-structured deal where PPT, as a conduit trader, did not care what the actual prices was. All it cared about was its margin. And in fact, if I've seen many of these deals before, the conduit trader has no say in anything. It's only given a margin and said yes or no, and then they jump along to that. Another point raised against PPT acting fraudulently is the concept of round tripping, that the goods were going on a round trip back to Zenrock. Third is a point related to Trafigura that was meant to be a possible buyer in this chain at one point, but Trafigura pulled out, and they pulled out because they had wanted the original BLs or an LOI countersigned by a bank. And another point I think they sort of raised was PPT was not involved in the shipping. Now, this is, they're not involved in the shipping of an FOB contract, which is a bit odd because naturally someone must have been involved in terms of getting the goods there to the destination. What was the court's decision on this? The court said, that on balance, it seems that PPT knew, the witnesses involved for PPT knew that there was round tripping, but the round tripping itself was not unlawful because they did not know of the fabricated contract. And that's why I mentioned the fabricated contract is the key to keep your eye out on knowledge. They did not know of the fabricated contract, and in and of itself, the round tripping itself was not unlawful. The court also held that there was no knowledge of the inflated prices. I'll come to that in a second as to what my view is. The court took the view that, PPT believed that they had good title. They had good title and they could pass good title. They were not dishonest. And even if there was a reckless failure by PPT to verify the trade or the representations they were making, that didn't vitiate the presentation. And there's a distinction there held by the courts with DG. DG are cases dealing with demand guarantees, which for most part have been treated synonymously or on the same footing as letter of credit cases. The last point is that the beneficiary owes no duty as to presentation. When the beneficiary makes a presentation to the bank, it does not owe a duty to the bank to ensure that it's not negligent in its presentation. The other finding then was one of the accusations put forward by Credit Agricole was that this transaction was a sham. And I think there the court held that this wasn't a sham. It wasn't a sham because whatever the motives of this round tripping exercise was, it did not, it's irrelevant, it did not matter. What the chain of contract did create were binding obligations with respect to Shandong, PPT, and then on to Zenrock. These obligations were binding, and that's fine. The fact that no BL was passed, no original BL was passed between the parties, that itself did not actually go towards the propriety of title. In respect of misrep on title, they said there's no misrep on the title, no duties owed. On the LOIs, I'll come to this actually now's the time to deal with it. On the LOIs, the question raised before the court was that the LOIs contained all these warranties, and the warranties were PPT say, I have title to these goods, I have authority to deal with this, to transfer this title, and I can endorse BLs. And at the time, I don't have the BLs. And when I do receive the BLs, I will give it to you, the bank. This is standard LOI documentation that goes about. And I will indemnify you if I don't have, for the lack of BLs. So in most cases dealing with misdelivery and so on, the LOI is actually what gets triggered in this case. The bank here said, okay, all good and proper, you've got this LOI and it contains all these warranties, but 2 points. The LOI, this warranties was conditional on payment. You pay, meaning the bank has to pay before it receives the warranties. And that's because there's clear language in the LOI itself, once again, standard language, to say in consideration of payment, A, B, and C will happen. The bank also said that, the court also said that, there's a distinction between a warranty and a representation. I'll tell you why this is important. A warranty is a promise. Let me give you an example. I warrant I will paint your house blue. I promise that when I'm done with this job, your house will be blue. That's a warrant into a future conduct. A representation is something more akin to do with what's the current state of affairs or facts now. So I represent to you now, my house is blue. That's a representation. And if you come and you find that my house is not blue at the time of buying my house, then what you're entitled to is actually to rescind the contract. So that's the distinction between a warranty and a representation. A representation gives you a claim for misrepresentation. Had you not misrepresented this state of affairs, I would not have entered into the contract, meaning that I get to unwind the contractual obligation. A warranty sounds in damages. It doesn't unwind the contract, it doesn't put parties back. It put parties as if the promises had been done. So, whatever losses you've suffered for my house not being blue in the future, yes, that's a breach of warranty, and that's where you get to claim those losses. I have a poll to ask, and I actually put this down over here. And so these are the brief facts of the case. And before I go into my analysis of it, I actually wanted to ask and keep the audience up on its toes as well, as to, having explained as brief as possible what the case is about, what is the audience's view about whether PPT should be entitled to claim under the LC? I'm going to, I've put it up on the screen. I hope you can see it. I'll just give you a few minutes for people to answer. Should PPT be entitled to claim under the LC? This is a hypothetical question, obviously, because PPT was held to be entitled to claim under the LC. But I want to get a sense of rights and wrongs, of sense of justice and fairness from the audience, and how to understand what the audience thinks of how an LC should work. Okay, we'll just give it a few more seconds. Okay, 60, oops. You see what I answer, guys? Okay, about 70% says that PPT should be entitled to claim under the LC. 21% say no, and about 10% say they don't know. Okay, the point of this webinar is not to tell you whether it should be claimable or it shouldn't be claimable. I think that isn't the point of what I'm trying to do over here. What I'm trying to come across is actually a critique, and most lawyers will send you these updates, these presentations, and tell you what the court said. I'm going to go a bit further, stick my neck out and say, I don't agree with some parts of it. And I think that's something that most lawyers actually would shy away from, actually. So I say this with all respect to the lawyers involved in this case and also to the judge himself. Okay, so let's start with the analysis of the case. The analysis of the case, one of the key points over here I found was that the judge said recklessness does not matter. Recklessness matters in demand guarantees, but when it comes to letter of credit, it does not matter. And to understand this statement, I think let's take a step back and understand the case law around letters of credit and this fraud exception. It involves basically 3 or 4 classic cases. United City Merchants is the House of Lords decisions that is the classic case set up to show the autonomy principles of letters of credit and how this is actually meant to be sacrosanct. And this was applied in the Singapore Court of Appeal in Brody, White and Co. And I'm reading out from the slide, and the exception to claiming under an LC is that if the seller, i.e. the beneficiary, fraudulently presents to the confirming bank documents that contain representations, material representations, that to his knowledge are untrue. This was stated in United City Merchants, is held up to be the classic statement, and it was applied in Brody in the Singapore Court of Appeal. Now, there's another Singapore Court of Appeal case involving Arab Bank, and here we talk about recklessness. Arab Bank involves a demand guarantee, and in that case, the test of fraud was meant to cover. The test of fraud included the tests involving recklessness, and I'm going to read out the test because this is the heart of the analysis over here. In Arab Bank, it said it would be fraudulent for a person to make a false representation if he was recklessly indifferent to the truth or falsity of that which he was asserting at the time he made the statement. If he was recklessly indifferent to the truth or falsity, that's the classic definition of recklessness in fraud. The test of fraud comes in large part from the tort of deceit, and in the tort of deceit meaning that you deceive someone, it includes this element of recklessness, which is a bit of, it's not just knowing something that you positively know it's wrong or untruthful. It's also a bottom line argument, and a bottom line argument says that if you were indifferent, if you closed your eyes to the truth, if you did not really care whether it's true or not, then you are deemed reckless. And if you're deemed reckless, that falls within the definition of fraud. And so then that should fall within the fraud exception. So if we take it in comparison, we've got two quite differing views from the same Singapore Court of Appeal. One says, one quotes United City Merchants saying, the beneficiary must know that this is that representations are untrue. The beneficiary must know that. Second case, Arab Bank saying fraudulent is someone that is also indifferent to the truth of the representations being made. What did the judge in Credit Agricole decide? And I've cited the passages over here and the two parts that I think are of valuable assistance or review. At paragraph 20 of his judgment, he says, okay, I'm following Brody, and Brody stands for the proposition that when it comes to letters of credit, the only way, the fraud you're talking about in letters of credit is the fraud in presenting the documents. Either the documents themselves are fraudulent or there is fraudulent presentation. When you present it, you are being fraudulent. And that means presenting something that you know is false or not having the belief that it's true. It doesn't include the recklessness argument that I spoke about. It actually requires positive dishonesty. And this is where in paragraph 22, the judge goes on to say, in the absence of any presentation of a false fabricated document to Credit Agricole, in order to establish a valid defense of the claim under the LC, it would not be enough to show that PPT was reckless in not inquiring into the purpose of the round-tripping exercise without showing that PPT knew that the purpose was to effect fraud on Credit Agricole by producing a forged sale contracts. So the analysis to the judge was this. You must know, just because there's a round-tripping, that's not enough. You must know that there's a round-tripping, and the round-tripping was meant to deceive Credit Agricole, and it was done by way of producing the forged sales contract. Now, did PPT know what was being done down the line, that there was going to be a forged sales contract? It doesn't look like it from the evidence. But is that enough to say that they were not reckless? The judge goes on further to talk about dishonesty being the key part of fraud. And this is where I, with all due respect, differ from the judge's view, because I feel that recklessness is an essential part of fraud, and it should fall under the letter of credit stance as well. So in its case, I think the judge makes very clear over here that, and I've highlighted the words over here, a reckless presentation made without investigation cannot vitiate the presentation. An absence of belief in the truth of the presentation in the sense of not caring whether it's true or false. That's the classic definition of recklessness. It's enough for deceit, but it is not enough for non-payment under a letter of credit. I repeat over here, this is the words from the judgment. Even a reckless failure to ascertain the truth of the representations, which were made in the honest belief that they were true, will not amount to fraud for the purposes of non-payment under the LC. In my judgment, there's a distinction between the law relating to letter of credit and the law relating to demand guarantee. So nothing in Arab Bank impacts upon earlier decision in Brody. So you remember I mentioned there was Brody saying the classic view, which is basically fraud equals actual knowledge. And then there was Arab Bank that sort of went with the common law view of fraud, which means that recklessness is included as well, not caring whether it's true or not. But nothing in Arab Bank impacts the Court of Appeal's earlier decision in Brody. Let's test whether that's true. Let me take you to Arab Bank. And in Arab Bank, this is the statement, I've pulled it up from the judgment in Arab Bank itself. And it says that there is no distinction in the operation of the fraud exception in the context of letters of credit and demand guarantees. The application of fraud is the same. And I just took you to the part that showed that fraud in demand guarantee includes recklessness, includes not caring whether a representation is true or not. At the same point, the court in Credit Agricole refers to DBS versus Carrier, another case in Singapore, to support its position that the fraud test does not include the representation does not include recklessness. But in DBS versus carrier, the arguments about fraud, the tests on fraud included these three forms of fraud. Number one being where you know the representation is false. Number two is when you made the representation without belief that it's true. And number three is when you made not caring whether it's true or false. And that number three is the point of recklessness. This came up in DBS versus carrier. The court did not mention that in DBS versus carrier, the bank there actually succeeded in showing fraudulent misrepresentation in a claim for getting the money back. So the question now is, are there different tests for fraud? Do you apply one test for fraud when it comes to demand guarantees, another test for fraud when it comes to letters of credit? And if so, why is there a distinction between the two? I submit my personal view is that I don't think that there should be a distinction between demand guarantees and letters of credit. If anything, the case law of letters of credit would have predated that of demand guarantees. Letters of credit have existed well before the concept of demand guarantees have existed, from what I understand. So let's go back and try to assess, having just given you what I feel that recklessness matters, it would matter to the actual finding of the case. Let's go back and see whether there were elements of recklessness in this behavior. And the key part now is to actually look at what wasn't the case that we are dealing with Credit Agricole, which was actually involving Shandong PPT and then back to Zenrock. There was an earlier negotiation involving Trafigura, and that earlier negotiation shows you a thing or two as to what the state of mind of the people involved were. And this is, let's take for example, the evidence provided by PPT. The evidence provided by PPT is that, it's essentially inserted into trades. It does so as a credit sleeve, and when it's a credit sleeve, then it checks on the sell and buy, and then it inserts itself through. That doesn't ring through to my understanding of how a credit sleeve operates, but that's what PPT says it is. Another reason why PPT inserts himself is because one of the companies wishes to keep a low profile. Fair enough. And the third is to fulfill a payment gap. And this is once again a credit position that by inserting themselves, PPT can pay in 10 days what the buyer can only pay in 60 days. So it's effectively giving a credit position. And these are legitimate reasons for a party to be involved into the trade. I stop there for a second and before I get into the TRAF deal. And I want to talk about credit sleeves and my understanding of how credit sleeves work. We do a lot of oil trades and bunker trades, and yes, there are credit sleeves used. And the notion of a credit sleeve is that you don't have enough credit of your own. And so a smaller trader relies on a bigger trader, on the biggest trader's capacity to get credit, and then it sleeves it through. Over recent years, I've seen people start using this concept in a reverse situation, where a smaller trader is inserted to effectively raise financing in between two large traders. And it sort of beggars the question. There are two large traders and there's a small trader in between. Who really needs the financing over here? Who's raising financing for who over here? This is a consideration that needs to be given. So let's bear in the three reasons why PPT said it was what its evidence as to why what its business model was like. And then let's look at the attempted deal with Trafigura. This was an attempted deal that was aborted in the end. So Traf and Zenrock could not deal directly. So one of the issues being that the point number two, a party wants to keep a low profile. But in this case, I think during the negotiations, it became clear that Traf and Zenrock knew each other and so on. So there's no reason for that to be an applicable reason to be inserted into the chain. PPT, no reason was given to PPT as to why it was being involved in the chain, and nor did it ask. What it did say to Zenrock when being inserted into the chain is, you always help us, we can do something for you. What does that mean? I think it's open to interpretation. And then there is this notion of financing deal. Remember I said that a party inserts themselves because it's effectively giving credit. But in the negotiation with Trafigura, it was effectively payment on the same day. So there was no element of credit period being provided. So point number of the three reasons, point number 3, point number 2 fall away, point number 1, a credit sleeve for Trafigura. I'll leave it at that. Just, I think that should be obvious in itself. Now, the other point about this deal over here, this proposed deal, was that PPT knew that Zenrock would then buy from Trafigura. So it was a seller down the chain, and then it would be a buyer up the chain. But the part that I find most troubling in PPT's evidence is this, is that within minutes of Trafigura pulling out, and Trafigura pulled out for its own reasons, Zenrock went back to PPT and said, hold on, I don't need to be, instead of being a seller to you under this proposed deal, let me be a buyer. Let me completely change the transaction from me selling to PPT and then buying to Trafigura. Now let's create this new chain involving Shandong, PPT, and Zenrock. Once again, it's also quite clear that Zenrock was getting involved at the end of the chain as well. A new buyer was inserted, Shandong. So from these commentaries, this is the evidence pulled out of the judgment as to what the discussions were like, and I think it's quite critical in my mind in analyzing the case. And one of this is that the discussion from PPT's staff and a Mr. Live from Zenrock. So here at the top part, we have Zenrock's employees saying, yes, such financing deals, they are honestly under scrutiny. This was during the discussion about Trafigura. I usually wouldn't want to come to you guys, but this is an issue to my boss. Why don't you guys propose back a chain that best works for you, and we can accept it, sort of thing. So there's a discussion saying these deals are under scrutiny. And then there's a key part in paragraph 63 over here, and this is during the negotiation, Zenrock tells PPT, Trafigura and us, Zenrock, are using CA, Credit Agricole. Is it possible for PPT to use another bank? If not, CA may see our whole chain, as long as you won't use CA SIG. So it's quite clear over here that there's an element of deception being involved, that Zenrock wanted to deceive or did not want Credit Agricole to see the full chain. And if it saw the full chain, the obvious thing it would see is that Zenrock was selling the cargo down the line and buying from itself further down the line. And this would raise questions. The judge in this case decided, okay, even if all of this is true, that doesn't mean that PPT knew that there was a fabricated contract being done down the road. And I agree with that. I think it's a bit far-fetched to say that PPT would have known about the fabricated contract being down the road. But let's look at what PPT was indifferent to. And this is, no need to talk about what they actually knew. This is a matter of evidence. I think the evidence was before the court. But we're talking about recklessness over here. If the test for recklessness is to be applied, or recklessness is to be included, what would constitute reckless behavior here? And these are the points that I think can be argued to be reckless behavior. Let's go through some of the points. This is a trade for oil, so no original BLs were being used. But in the judgment, it's clear that PPT paid no attention to the transfer of ownership. So I stop here to say, you're buying goods in a trade. You don't know who your seller is. You're buying from a company called Shandong. You've never heard who Shandong is before. You've never dealt with them. I don't know whether you've dealt with them, but it didn't seem from the evidence that they had. And you were not receiving BLs, the title documents to goods. But yet what you were receiving was a contract saying that they sell you these goods. It's, well, I was going to use a poor analogy, but I'll stop there. I wouldn't exaggerate it too much. So there is, as a buyer in this chain of contracts, there was no verification done as to the title of the person selling the goods to them. I'm putting myself in the shoes of PPT and assessing whether that is reckless behavior. PPT says that they're inserted because their clients can't issue LCs. but PPT never asked about its role. Its only concern was on its profit margin. It did not verify the title. There's no evidence to say what steps it took to check that Shandong had good title, and it was passing good title on down to back to Zenrock. The judgment, I think, shows that PPT's witnesses were evasive, and they did not consider the market price. And I think this was a key finding by the court, that they did not know that the market price was 87% or significantly inflated from what the actual cargo was. In my personal view about this, having worked with traders, knowing traders day in, day out, I find this quite unbelievable, that a trader would be in a business and not know that a cargo is actually 87% inflated. A couple of basis points up and down, fine. A couple of points on the indices, fine. But 87%, that just sounds a bit, too extreme for me. The court also said that it was clear that PPT knew that Zenrock was a seller and later the buyer in the chain, and that the swapping was happened, that from Zenrock became a seller to a buyer, and it wanted to, not it wanted to hide, but Zenrock wanted to hide this chain away from CA. So if you in PPT's position, I don't know what could be done. It seems to me that, as they mentioned, their main concern was the profit margin, and I think that came at the expense of everything else. Where there were these red flags ringing out, PPT said, "I'm not going to ask about this red flag. Why is the cargo worth so much more than before? Why is Zenrock buying the cargo back itself again?" Not going to ask any of these questions. And when I look at it now, being a commodities lawyer, and I look at it and I think it seems quite obvious. Obviously, with the benefit of hindsight, it seems quite obvious that I wouldn't go as far to say that this knowledge about a fabricated contract and so on was alive. I think that is not true. But what is true is that it seems reasonable to infer that Zenrock was getting financing twice on the same cargo, and one of which at least involved a very inflated sum. So it's getting a huge sum of money just for being in its position and circulating a couple of documents around. It didn't circulate the BL. It didn't circulate anything else. It circulated a couple of sale contracts, some shipping documents, the LOI, and for that, it got liquidity in the form of a double financing. The question from PPT's point of view, and the question, I think, of policy for courts to consider is this: is how much closing of the eyes would it be before it can be said to taint the hands of the beneficiary, where there is evidence of the cargo being inflated, where there's evidence that there's double financing, where it's clear that that the realistically there's a real question mark about whether the title is really passed between the different parties. Yes, I appreciate that a sales contract says the title is passed, but apart from that, nothing more to substantiate it. In a case that Zenrock is the start point of the sale contract, the circular trade, back to itself, and no BL is being passed down the chain, I find more needs to have been done to verify the title. I think that's a key assessment that could have been considered in this case. I'm running out of time. I have a lot to say about this, as I mentioned before, and I'm going to jump quite quickly to reps and warranties. And I think this is quite important over here to do with the LOI. I've put the LOI language involved in this case from the judgment out for you. I think it shows you the incredible value of 23 million over here. And the LOI is a safety net for the banks, because the banks look at it and think, okay, there's no BL. Why is there no BL? On a different day, I'll sit down and give you the history about how oil traders have moved away from using BLs for these sort of trades. But there is no BL. So what's the next best thing? LOIs. And the LOIs will contain a warranty saying, I've underlined the warranty over there, a couple of warranties. I've got good title, it's free of any encumbrance, I've got full right and authority to transfer this title to you. I'm entitled to receive documents, the original BL from the supplier, and I'll transfer them to you when I do. If I don't do all of this or anything breaches, then I will indemnify you back for paying $23 million on my behalf. For paying $23 million to me. So these warranties are an essential part of the LOI. And the unfortunate part over here is that by circumstance, Credit Agricole did not pay because it felt that, wait a minute, there is, strong suggestion of double financing with two different banks. So it didn't pay. But because it didn't pay, the warranties did not kick in. The word in consideration of making payment meant that without pay, these warranties don't mean anything. And so now I think traders, banks, everyone's scratching their head thinking, should we change this wording? Very standard wording in letters of indemnity. Should we say in consideration of opening the LC? The act of opening the LC itself is the one that should attract the warranties, or should it only apply after payment is made? I've got 5 minutes. I see people are still on the call, so I'll keep going as far as I can. I do want to take some questions. And the last point I want to touch over here is to do with fake documents. This doesn't deal with Credit Agricole itself, but I think there's a string of cases involving faked and forged documents and how that entitles a bank not to pay if documents are fake. I bring this up because I think some of the rationale underlying that applies equally in the case where you have a beneficiary putting forward documents of representations where it couldn't care less whether it's true or not. And there are two cases in Singapore. So the English case law is very strict in the sense that it follows that United City Merchants doctrine, where only clear evidence of the fraud on behalf of the beneficiary is going to impact the payment. But in Singapore, there is a bit more wiggle room, and some people have called it a nullity exception, although it's not strictly speaking so much a nullity, but perhaps better viewed as a lack of conforming to the right documents that are being applied. So for example, if the documents require certain certificates, material certificates to be provided, and these turn out to be fake or forged, can the bank then say, no, I'm not going to pay? Why should the bank have to pay if it knows that this document is forged? And I'll give you an example of the BL. Now, in a previous time, we didn't know that BLs circulated, all manner of fake and forged and copy BLs circulated in the world. Now we do, So I think banks are increasingly suspicious about it. And if the bank gets a suggestion that there are two BLs for the same cargo circulating around, should it, for one BL must be a forgery, should it then pay? If it even establishes clear evidence that there's one is a forgery, should it still pay? Because on the terms of the letter of credit, it's meant to pay. It is a BL. The BL says what it says, and it's meant to pay. A box-ticking exercise. The two cases in Singapore where the court decided, no, there isn't, you aren't going to pay, or the bank doesn't need to pay, is a case involving Lambias, another case involving Beam. Lambias, I think it's a bit exceptional because the beneficiary had some role in the fraudulent document that's being presented. It was not consciously aware of what it was doing, but it put forward a certificate on its own. It signed off on a certificate that was meant to be signed off by the buyer in its case of actually trying to claim some money. In B, the situation over there involved airway bill, airway bill being something like a BL in a manner, contract and evidence of goods going, and that airway bill was by a company that did not exist. So I'm going to read that judgment out of Beam over here, and it's quite important because I think it sort of tells you what that mindset should be when dealing with letters of credit. Do we take a very siloed view? Because if we take a siloed view and we keep doing it, then I think we are opening up the banking system. As much as we want to keep it going, we are also opening it up to abuse at the same time. And I'm reading from the judgment of Beam over here, where it says implicit in the requirement of a conforming document is the assumption that the document is true and genuine. And in the interest of international trade, the bank is not required to look beyond what appears at the surface of the documents. That's true. But to say that a bank, in the face of a forged, null, and void document, even though the beneficiary is not privy to that forgery, must still pay on the credit defies reason and good sense. I see great value in this statement. I think it helps to apply a bit of common sense away from a very methodical approach towards letters of credit. And I suppose I had one more poll to see if your views on this case had changed, but I think I will, in the interest of time, I will forgo that poll. I would stop here and stop with where I started. Then the question that I asked, in the case of letters of credit, who should bear the risk? The bank or the beneficiary? Both, assuming both equally innocent, put it this way. And I'm taking the case of United City Merchants, the classic case. This is Court of Appeal though. It got overturned at the House of Lords, the court above it. But it's important because I think this is where I think the state of the law should be, even though it is not as it is right now. And it says quite importantly over here, the banks naturally trust the beneficiaries to present honest documents. If the beneficiaries go to others for the documents they present, certificates, third parties, and so on, and it turns out to be untrue because they got deceived, I see good reason. There's good reason for between the choice between two innocent parties, putting the loss upon the beneficiary and not the bank or its customer. And the reason why I say this is this. Fundamentally, if we take a step back and we look at how the transactions are done, who is best placed to understand the transaction that's being carried out? The party doing the trading in the underlying transaction, or the bank who is looking at it from a triangular point of view? He's just looking at the seller, its client, the applicant, and the buyer down the road. That's the narrow view that a bank gets to see. So in these circumstances, who should really bear the loss? And in the Court of Appeal, Lord Justice Stevenson commented that it should be the beneficiary, not the bank. This is not the state of the law. The law was overturned in the decision in the House of Lords, and it's very much in favor of the beneficiary, in the sense that if the beneficiary is innocent, the bank has to pay and then seek its recourse elsewhere. So thank you for joining, everyone. Let me recap today's session within the hour on the views of Credit Agricole. I think the case is massively interesting. I think in particular, this consideration of whether recklessness applies to the test of fraud. That has been decided in Credit Agricole that it is not. You must have actual knowledge of the fraud, and that today, as matters stand, is the law. Whether that gets changed in subsequent cases, that's to be seen. I have put forward my analysis over here, over parts of which I think could be considered, could be distinguished in subsequent cases as well, in terms of how this analysis was applied. And the point I want to make over here is that I could well be wrong about it. I'm only coming from the perspective of having worked in a lot of oil trading cases before, understand the nature of the players involved in this market, and trying to reconcile the different competing policy considerations in letters of credit, in particular, whether we want to have a system of international trade where banks are unwittingly used in all manner of, not all manner, in some manner of fraudulent schemes. Thank you, everyone. I am happy to take questions. Time has passed, so I'm happy to take questions. Please feel free to email me your questions. I'll answer them separately. Thank you. Have a good day. Bye-bye.